Welcome to the Deep Dive. Today we're going deep into administrative law in South Africa, and you've given us this study guide to help us out.
Yeah, this document's really interesting. It's full of these real-world cases that help us see how this area of the law actually works, in practice.
Yeah, it's like we get to peek behind the curtain and see how the South African government interacts with its citizens every day.
And it's a system that's changed a lot since the end of apartheid, and a lot of those changes are highlighted right here in this study guide. So what we're going to do is walk you through the core ideas of administrative law, pulling examples from the document.
So Chapter 1 dives right into this idea of state authority and who holds it. It sounds kind of intimidating at first,
Right.
but think about a time you had to deal with like a government agency.
Yeah.
Did you ever feel kind of powerless? Like when you're dealing with a traffic ticket or you're trying to get a permit?
Yeah, that feeling of the system is bigger than me. That's exactly what administrative law is trying to deal with. It makes sure the government doesn't do more than it's allowed to. And it also makes sure that you as a citizen can challenge decisions that affect you.
That makes sense. And the document actually uses this story about a student named John Lerner to show how state authority can affect individuals.
Oh, that's a perfect example. So the school in this story is acting like what's called an organ of state. They have the power to expel John, but they have to do it lawfully and fairly.
I was going to ask about that organ of state. Does that just mean like government departments?
Well, Section 239 of the Constitution defines organ of state, and it's actually broader than just departments. It includes any group using public power or doing public work based on the law.
So that could even mean like private organizations, right? Like let's say a private security company gets some law enforcement powers.
Yeah.
That kind of blurs the lines a bit.
It definitely does. The study guide actually quotes a judge from a case, Chiraw v. Transnet, and the judge says that figuring out what counts as a public function is notoriously difficult. It's one of the main things this chapter wants us to learn.
Okay, so we've got state authority.
Yeah.
We know who might have that power. What else does Chapter 1 want us to understand?
Well, it's not just about this big, faceless state making decisions for everyone. Administrative law also looks at your individual relationship with the state. The chapter calls these general versus individual administrative law relationships.
So like a municipality has a general duty to give people housing, but when you apply for a house specifically, that creates a special relationship between you and them.
You got it. And these different relationships are affected differently by things like changes in the law. For example, a new housing policy might not affect someone who already applied under the old rules. Understanding that difference is key.
That makes sense. Okay, so to wrap up Chapter 1, we learned about state authority, the different groups involved, and the different relationships this area of law deals with. It's a lot, but the document breaks it down pretty well. Where do we go from here?
Okay, Chapter 2 digs deeper into those relationships, specifically the different roles each party plays. So we'll see how the power dynamic works between the person in authority and the person in a subordinate position.
Like the example in the document with the Director General of Health making a decision about an official who reports to them. Even within the government, those relationships exist.
Exactly. And things get even more complicated with this idea of delegation of power, which is introduced in this chapter. That's when a person in authority hands their power off to someone else. And this can have big implications for who's responsible. Understanding how delegation works and its limits is another key goal of Chapter 2.
Oh, I can already see how tricky this can get. But hey, that's what we're here for.
Right.
To figure it all out.
Mm-hmm.
All right, so onward to Chapter 3, the legal subjects of administrative law. What's the main idea here?
Chapter 3 really gets into who exactly is using public power. We're going beyond just knowing what an organ of state is and looking at what it really means to hold state authority.
So not just knowing the definition, but knowing how to use it in real life.
You got it. Remember John Lerner's case? This chapter wants you to pinpoint who exactly used state authority in that situation. It wants you to analyze real-world examples and use what you know about the concept.
And the document also brings up things like clubs, associations, private organizations. Could they be seen as organs of state?
That's where things get interesting. They might not be created by the government like a department, but they can still do public work. Chapter 3 gets you thinking about where state authority ends and how it might show up in unexpected places.
So even a sports club or like a professional association, their internal decisions could sometimes fall under administrative law.
Right. And this chapter uses cases like government of the self-governing territory of KwaZulu v. Malangu to show how courts decide when those groups have to follow administrative law principles. It's about understanding that fairness and accountability apply beyond just the government itself.
Fascinating. All right, so we've covered the first 3 chapters, and we have a pretty solid foundation for understanding administrative law in South Africa. We've looked at who has power and the different ways those relationships can play out. What's next on our deep dive?
Chapter 4 is like going on a treasure hunt. It's called Sources of Administrative Law Power, and it's all about figuring out where these administrative groups get the right to act in the first place.
I'm guessing it all starts with the Constitution, right? That's the base for everything in South African law.
You got it. The Constitution sets the rules, saying how all organs of state have to use their powers. But Chapter 4 takes you further. It guides you through these other important sources of administrative power. We're talking legislation, case law, common law principles, even administrative practices.
It's like we're putting together a puzzle using all these different sources to figure out what the rules are and how they work.
Exactly. And here's where things get really interesting. Chapter 4 brings up this concept of Ubuntu, which reflects South Africa's unique culture and legal landscape. Ubuntu is all about community fairness and human dignity, and it can actually influence how courts understand and apply administrative law principles.
Wow. So it's not just about rules in a book. It's about understanding the social context and making sure the law is used in a way that promotes justice and fairness in a uniquely South African way. What a great way to wrap up Chapter 4. Now on to Chapter 5, which digs into administrative action. What are the key takeaways here?
Chapter 5 gets down to business. It's about defining what administrative action really is, and this is where PAJA, the Promotion of Administrative Justice Act, takes center stage.
PAJA, I knew this was coming. It's like the backbone of administrative law in South Africa.
Right. You bet. Chapter 5 introduces PAJA as the legal framework that takes that right to just administrative action from the Constitution and makes it real. It lays out the rules explaining how administrative decisions should be made, the reasons you can challenge those decisions, and the remedies you have if you've been treated unfairly.
So it's like PAJA takes those big constitutional ideas and turns them into real-world procedures and protections.
Exactly. Chapter 5 walks you through PAJA's definition of administrative action, making it clear that it has to involve a decision by an administrator that affects someone's rights. It also breaks down the different types of administrative action, legislative, judicial, and so on.
And I see the document includes some scenarios, too, like, remember Theodore Refugee who was seeking asylum. This chapter might ask if the officer's decision on his case counts as administrative action.
Exactly. Those scenarios help you really understand PAJA and how it's used. By the end of Chapter 5, you should be able to spot administrative action, understand the basic framework of PAJA, and recognize the different forms it can take.
This is fantastic. We're really seeing how these ideas work in the real world. Now let's move on to Chapter 6, just administrative action. This one sounds important.
It is. This chapter is all about unpacking Section 33 of the Constitution, which guarantees everyone the right to just administrative action. It's about making sure the government, when it acts, is doing so fairly, reasonably, and lawfully.
We've talked about those principles before: legality, reasonableness, procedural fairness. But Chapter 6 really dives into what they mean in practice.
Exactly. It uses real-world examples to show what it means for an action to be allowed by law to be rational and justifiable and to follow a fair process. We also get introduced to ideas like the principle of legality and the rule against bias.
The document also mentions Section 195 of the Constitution. How does that fit into just administrative action?
Those are the values and principles of good governance. Things like accountability, transparency, responsiveness to people's needs. Chapter 6 highlights how these are woven into the idea of just administrative action. It's not just about following the rules, but making sure the spirit of good governance is there too.
Okay, so Chapter 6 gives us the ethical framework for how administrative action should work. What's next?
Chapter 7 takes us deep into the right to lawful administrative action. It breaks down what lawfulness really means, and it's more than just saying it must be allowed by law.
Remember earlier we talked about a situation where a municipality went too far and started giving out fines for something that wasn't actually against the law? That seems like a good example of this.
You're exactly right. Chapter 7 gives you the knowledge to analyze whether administrative actions are actually authorized. It takes you through the Constitution, PAJA, and case law to break down the concept of lawfulness. By the end of this chapter, you should be able to spot those red flags that tell you an action might not be legal.
So we're learning how to hold the government accountable, making sure they're following the rules by the law. What else does this chapter cover?
It also stresses knowing the specific powers given to different administrators. For example, if someone acts outside of their area, they might be acting unlawfully. We also revisit that idea of delegation of power and learn the rules for when an administrator can give their authority to someone else.
Like that case with the Minister of Education giving power to a university council. Chapter 7 would ask us to analyze if that was legal and what would happen if it wasn't.
You got it. It's about going deeper than just surface-level understanding and really getting the legal framework behind every administrative action.
We've covered a lot already, but it feels like we're building a solid understanding of these core principles. Now on to Chapter 8, the constitutional right to reasonable administrative action. What's the focus here?
This chapter tackles reasonableness, which basically means government actions have to be rational and justifiable. It's not enough to just act within the law. The decisions have to make sense, too.
I remember from earlier chapters that reasonableness wasn't always a separate reason for review. How did that change?
It's an interesting story. Chapter 8 explains how at first courts didn't want to interfere even if an action seemed unreasonable. They were worried about overstepping and getting in the way of the executive branch. But then the Constitution came along, and it clearly said everyone has the right to reasonable administrative action.
So that gives the courts more power to review decisions that seemed irrational or unjustifiable.
Exactly. Chapter 8 walks you through how courts now understand this right to reasonableness. It uses big cases like the Standard Bank of Bophuthatswana Limited v. Reynolds case, which moved away from that old gross unreasonableness standard to a more specific approach.
It's really interesting to see how the law has changed to better protect people. What else does this chapter focus on?
It makes you think critically about what reasonableness really means. We're introduced to the idea of proportionality, which means the methods the government uses must be in line with the goals they're trying to achieve.
I bet the study guide has some good examples that show this, like maybe a prisoner who's denied parole.
You bet. Chapter 8 wants you to analyze cases like that, asking, was the decision reasonable given the circumstances, or was it too harsh compared to the risk the prisoner posed? By the end of this chapter, you should be able to judge the reasonableness of an action and understand how you can challenge unreasonable decisions.
That's really helpful. Okay, we've talked about lawfulness and reasonableness. What's next?
Chapter 9 brings us to procedural fairness in administrative law. This is a big one because it's all about making sure individuals are treated fairly when decisions that affect their rights are being made.
I remember that story about Cello's food stall from the beginning of the document. It showed how bad it can be when there's no procedural fairness, even if the final decision might be technically legal.
That's a perfect example. Chapter 9 says that even if the outcome is right, the process of getting there has to be fair. It's about giving people a voice and a chance to defend themselves.
And that's where those common law rules of natural justice come in, right? Audi alteram partem and nemo iodex in sua causa.
You know it. Those are the Latin phrases for hear the other side and no one should be a judge in their own case. Chapter 9 shows how these principles have become part of South African law.
Can you explain those a bit more? What do they really mean?
Sure. Audi alteram partem means you have the right to be heard before a decision that affects you is made. This could mean getting a proper notice about what's happening, having a chance to tell your side of the story, and being told why the decision was made.
And nemo iodex in sua causa. That sounds like it's all about avoiding conflicts of interest.
Exactly. It's about making sure the person making the decision is impartial and unbiased. Chapter 9 goes into the different types of bias that can happen, like financial interests, personal relationships, or even strong opinions about the issue. It helps you recognize when someone might not be fair.
This is fascinating. So Chapter 9 is about the safeguards that ensure a fair process even before we look at the final result.
Exactly. And remember, it's not just about common law. Chapter 9 also explores how the Constitution and PAJA have strengthened the right to procedural fairness, giving you more legal tools to challenge decisions that weren't made fairly.
It's amazing how these concepts all build on each other. So after this chapter, we'll be able to figure out not just if the outcome was right, but if the process itself was fair and just.
You got it. Chapter 9 gets you ready to scrutinize administrative action from every angle, making sure the government is following the rules and treating individuals fairly.
This deep dive has been really eye-opening. Now on to Chapter 10, which focuses on a specific part of procedural fairness, the right to reasons. Why is this so important?
Chapter 10 makes it clear that it's not enough to just be heard. You also have the right to understand why a decision was made. Imagine being denied something important without knowing why. It would be super frustrating and make it much harder to challenge the decision.
It would feel like you're completely in the dark. Without knowing the reasons, how could you even start to argue your case or figure out if there were mistakes made?
Exactly. Chapter 10 digs into the importance of getting those reasons in writing, emphasizing how they help with accountability, transparency, and even improving the quality of decision-making. When officials know they have to explain themselves, they're more likely to be careful and thorough.
That makes sense.
Huh.
If they just tick a box or give a vague answer that doesn't really make them accountable.
Right. Chapter 10 might even use case studies to show this point, maybe one where a disability grant was denied without good reasons. The court emphasized that just ticking boxes on a form isn't enough. The reasons have to be meaningful, understandable, and give enough detail for the person to respond to the decision.
So it's not about getting any reason. It's about getting reasons that you can understand and they give you a chance to do something if you disagree. What else does this chapter cover?
Chapter 10 walks you through the legal framework that supports this right, including PAJA and relevant case law. It really empowers citizens to hold the government accountable, ensuring decisions aren't random, and that individuals can meaningfully participate in processes that affect them.
This deep dive is showing just how essential individual rights are in ensuring a democratic and fair system. What about Chapter 11? It looks at internal control of administrative action. What's that about?
Chapter 11 introduces internal control, which means the checks and balances that exist within the administrative system itself. So before going to court, there are ways to address mistakes, review decisions, and prevent abuse of power within the administration.
So things like internal appeals, complaint procedures, maybe even a specific person or office to handle these things.
Exactly. Chapter 11 shows how many administrative bodies have their own hierarchies and procedures for challenging decisions. It might highlight things like ombudsman offices that investigate complaints and recommend solutions.
So it's about having that first line of defense against unfairness or mistakes, making sure problems are fixed efficiently within the system.
You got it. It reinforces that accountability shouldn't just come from outside, like the courts. It should be built into how these groups work. Chapter 11 also discusses PAJA's requirement to use all internal remedies before going to court.
Right, I remember reading about that. It encourages people to try to fix the problem within the organization before taking legal action.
Exactly. It's a way to promote efficiency and keep the courts from being overloaded with cases that could be resolved internally. But the chapter also says there are exceptions to this rule, situations where going through internal channels wouldn't make sense.
So it's a balance encouraging internal control, but recognizing its limits. This deep dive is really showing how complex administrative law is. So what's next?
Chapter 12 takes us to the courtrooms. It's called Judicial Control of Administrative Action, and it's all about the role of the courts in reviewing and controlling what these administrative bodies do.
This is where it all comes together, right? The courts ultimately have the power to make sure the government is following the law and protecting individual rights.
Exactly. Chapter 12 stresses that judicial review is super important for protecting against abuse of power. It's about having an independent and impartial body, the courts checking up on those in authority.
So we're learning how people can challenge decisions and what the courts can actually do if they find something was unlawful or unfair. What are some of the important concepts we learn in this chapter?
Chapter 12 explains the different legal grounds for challenging administrative actions. We'll encounter concepts like ultravires, which means acting beyond one's powers, and we revisit procedural impropriety and unreasonableness, which we talked about earlier.
And of course, it wouldn't be complete without discussing the remedies right. What can the courts actually do to fix a bad decision?
Absolutely. Chapter 12 outlines all the different remedies the courts can use. They can completely cancel a decision, order the administrator to reconsider it, or even award damages to the person who was harmed.
So it's not just about saying something was wrong. It's about providing real solutions to make things right. What else is important to know about judicial review?
Chapter 12 also emphasizes the importance of access to justice. It's about making sure everyone has a fair chance to challenge unfair decisions, even if they don't have a lot of money or resources. It might even talk about the role of legal aid and other things that help people access justice.
It's about making the system work for everyone, not just those who can afford expensive lawyers. That's so important.
Exactly. And finally, Chapter 12 introduces the concept of standing. This means the legal right of an individual or group to actually bring a case to court. It makes sure that not just anyone can sue the government over any decision, but that the person suing has a real interest in the matter.
It makes sense that there have to be some rules to prevent pointless lawsuits and make sure the courts are dealing with the most important cases.
Exactly. And this chapter might even discuss the specific steps you have to take to start a judicial review, emphasizing the need to follow the correct legal procedures.
Wow, we've covered so much in this section. It's amazing how each chapter builds on the last one, creating a comprehensive understanding of administrative law and how it works in South Africa. Are we ready to keep going?
Absolutely. Chapter 13 takes us beyond the courts and internal procedures. It explores other forms of control over administrative action. It's like expanding our toolkit for ensuring accountability and good governance.
So what other options are there? What else can we do to make sure the government is acting responsibly?
Chapter 13 looks into things like parliamentary control. Members of parliament can ask ministers about what their departments are doing, examine policies, and even start investigations into potential wrongdoing. It's about making sure the people's representatives can hold the executive branch accountable.
That's really interesting how the checks and balances work in a democracy. We have the courts, the internal controls, and now Parliament all playing a role.
Right. And Chapter 13 might also talk about specialized bodies like the public protector. Remember them? They're like independent watchdogs investigating complaints about government doing things wrong and corruption.
Yes, they have real power to hold the government accountable and make sure things are fair.
Exactly. Chapter 13 would probably highlight how the public protector makes sure the government is acting ethically, respecting the law and the principles of good governance. It might even look at specific cases where they stepped in to fix injustices and protect individual rights.
It sounds like this chapter gives citizens even more ways to address problems and seek solutions. It's like a whole web of accountability.
You got it. And Chapter 13 encourages you to think strategically about these different forms of control. Remember that situation where the Minister of Education overstepped and appointed a school principal?
Oh yeah, that was a great example of how someone can misuse their power.
Well, this chapter might ask you to think about which forms of control would be most effective in that situation. Should the people affected complain to the public protector? Could they go to members of parliament and ask them to hold the minister accountable? It's about knowing your options and choosing the right tool for the job.
This is so empowering. It's not just about understanding the law, it's about knowing how to use it to make sure things are fair and people are held accountable. What's next?
Chapter 14 takes us to where administrative law and the Bill of Rights meet. It's called Administrative Law and the Bill of Rights. And it emphasizes that even when the government is acting legally and fairly, they still have to respect those basic rights that are in the Constitution.
Right, the Bill of Rights is like the ultimate protector of individual freedoms. Things like the right to equality, dignity, freedom of expression, those can't be violated even by government officials.
Exactly. Chapter 14 says that administrative bodies can't infringe on those rights even when using their powers. It's about protecting individuals from government overreach and making sure human rights are considered in all administrative decisions.
I bet the document has some examples of this, right? Cases where someone challenged administrative action because it violated human rights?
Absolutely. It might look at a government policy that was found to be discriminatory or a situation where someone's right to privacy was violated during an investigation. By the end of Chapter 14, you should be able to see when administrative actions clash with fundamental rights and understand how you can challenge those actions.
So it's like we're learning how to use the Bill of Rights to protect ourselves from government actions that go too far. That's powerful.
Exactly. Chapter 14 really shows that administrative law isn't just about boring procedures, it's about upholding the values of a democratic society and making sure those in power respect individual freedoms.
I can see how all these pieces fit together to create a system that's supposed to be fair and accountable. What about Chapter 15? It seems to be taking a broader look. It's called The Future of Administrative Law.
Chapter 15 is all about looking ahead and understanding that administrative law is always changing. It has to adapt to changes in society, technology, and new problems that come up.
So we're not just learning the rules as they are now, but thinking about how they might need to change in the future.
You got it. This chapter might talk about how digital technologies are impacting government services. How do we ensure online platforms are accessible, secure, and protect our privacy? And it's not just technology.
Right. It's also about how administrative law can be used to tackle big societal issues like climate change inequality and sustainable development. The law needs to be flexible and adaptable to handle those challenges.
Exactly. Chapter 15 might even ask us to imagine how administrative law can help create social justice, protect the environment, and empower communities. It's about seeing a future where these principles are used for good.
This deep dive is making me think beyond just what's in the book and see how administrative law can be a force for positive change in the world. So what's next?
Chapter 16 takes us beyond South Africa. It's called The Impact of International Law on Administrative Law, and it points out that we're not alone. We're part of a global community, and international law can actually influence how administrative law works right here in South Africa.
So things like treaties, international agreements, and customary international law, all those can affect how administrative law works in South Africa.
Exactly. Chapter 16 explains how those sources of international law come into play. For example, it might look at how South Africa includes international human rights standards into its administrative processes, or how it applies international environmental law to protect its natural resources.
Remember the story about Theodore refugee seeking asylum? I bet international refugee law was really important in his case.
Absolutely. Chapter 16 might talk about how international refugee law sets the rules for how countries should treat asylum seekers, figure out who's a refugee, and protect their rights. It shows that South Africa has to follow these international rules, which means its own laws and procedures have to line up with those global standards.
This really expands our understanding. It's not just about following our own rules, but also upholding international agreements. What else does this chapter emphasize?
It highlights how international law principles, like non-discrimination, procedural fairness, and the right to an effective remedy, can shape how administrative bodies work in South Africa. We might even look at specific cases where South African courts used international law to interpret their own administrative law or to review administrative actions.
This deep dive is showing how connected the world is, even when it comes to administrative law. It's like this network of legal principles that goes beyond borders.
Exactly. Chapter 16 makes you think about how international law can push South Africa to have higher standards of justice and human rights protection in its administrative work.
That's a great point. Now on to Chapter 17, which sounds really interesting, Comparative Administrative Law. What can we learn by looking at other countries?
This chapter takes us on a global tour of different administrative law systems. It's about getting a wider perspective, learning from different approaches, seeing what works best, and discovering new ways to solve common problems.
So we're comparing and contrasting how different countries handle administrative justice.
You got it. Chapter 17 might look at specific countries or regions examining their administrative courts, the reasons they can review decisions, the solutions available to individuals, and their systems for accountability and transparency. It might even compare common law systems with civil law systems, showing the unique features and challenges of each.
I imagine there's a lot to learn from countries that have had administrative law systems for a long time.
You're right. The chapter might explore countries like France, Germany, or the United Kingdom. They've had administrative law for a long time and have developed really sophisticated ways to balance government power with individual rights. We could also learn from countries that are newer to developing these systems, maybe in Eastern Europe or Latin America.
It sounds like a great opportunity to learn from what works and what doesn't.
Exactly. And we might even discuss the role of organizations like the United Nations or the World Bank in promoting good administrative law practices around the world. We could also look at regional groups like the European Union and how they've made administrative law more consistent across their member states.
This reminds me of that idea of reasonableness from Chapter 8. I bet different countries have very different ways of deciding what counts as reasonable administrative action.
That's a great observation. Chapter 17 might explore exactly that, comparing how different legal systems define and use the concept of reasonableness. We could look at the standards they use, the factors they consider, and how much they defer to administrative discretion.
It would be so interesting to see if there are any universal ideas about reasonableness that go beyond cultural and legal differences.
Exactly. Chapter 17 encourages you to think critically, to compare and contrast, to challenge your assumptions, and to explore creative solutions to problems we all face. It emphasizes that there's no one right way to do administrative justice, and that learning from each other can help us all improve.
What a great takeaway. It's like a global brainstorming session for administrative law. Okay, what about Chapter 18, Challenges and Opportunities in Administrative Law? This sounds very relevant.
Chapter 18 looks at the big challenges and opportunities that administrative law faces in South Africa today. It recognizes how complicated it is to govern a diverse and changing society and explores how administrative law can help us deal with these challenges.
I imagine some of those challenges have to do with poverty, inequality, and access to basic services.
You're absolutely right. Chapter 18 might explore how administrative law can be used to promote social justice and make sure everyone has fair and effective access to essential services. It could look at how to balance efficient service delivery with protecting individual rights and ensuring fairness.
So it's about using these principles to solve real problems and empower people, not just to control the government.
Exactly. And Chapter 18 might also talk about those constant challenges of corruption and maladministration. It could explore how to use administrative law to make accountability stronger, promote ethical conduct, and restore public trust in government.
This makes me think of Cello and his food stall. Even with a lawyer and knowing his rights, what if the officials were corrupt or just didn't want to follow the law?
That's a crucial point. Chapter 18 emphasizes that good laws aren't enough. The people using those laws have to be committed to fairness and accountability. We might discuss the need for better training for officials, strong oversight mechanisms, and real consequences for those who abuse their power.
It's about creating a culture of integrity, not just relying on rules.
Exactly. Chapter 18 encourages us to be realistic about the obstacles to achieving administrative justice, but also to keep looking for solutions. It reminds us that building a fair and effective administrative justice system is a continuous process.
This deep dive has been so informative, and I feel much more prepared to tackle the rest of this study guide. What's next?
Chapter 19 throws us into the 21st century. It's called The Role of Technology in Administrative Law, and it's all about how technology is changing how the government interacts with its citizens.
Yeah.
It's a whole new area for administrative law, full of challenges and opportunities.
I bet this chapter looks at e-governance, online service delivery, and how data analytics are being used in decision-making.
You're right on the money. Chapter 19 explores how technology is making administrative processes smoother, making it easier for people to get information, apply for things, and track their cases. It will probably talk about how online platforms can make things more transparent and allow for more public participation in government decisions.
So technology could make government more accessible and responsive to people's needs.
Absolutely. But Chapter 19 won't ignore the potential problems. We'll look at the risks of using biased algorithms for making decisions, the challenges of protecting privacy with all this data, and the need for digital platforms to be accessible to everyone, even those without tech skills or good internet access.
It's a good reminder that technology itself isn't good or bad. It's how we use it that matters.
Exactly. Chapter 19 stresses being ethical and responsible when using technology in administrative law. It's about making sure technology helps make government more efficient and just not less.
I can see how this chapter makes us think critically about technology's role in our lives, especially how it affects something as important as administrative law.
You're right, it's a really interesting area. Chapter 19 might even dive into the growing use of AI in administrative decision-making. Can AI systems process applications, decide who gets benefits, or even conduct investigations fairly and effectively? What are the ethical and legal implications of giving these decisions to machines?
Wow, those are big questions. It makes you wonder what the future of administrative law will be like as technology keeps advancing so quickly.
You got it. Chapter 19 encourages us to be proactive in shaping that future, making sure technology and administrative law work together to create a government that's efficient and fair.
Okay, so technology is definitely changing things. But Chapter 20 takes a step back and focuses on something that's always been important: ethics in administrative law. This feels especially important given all the power we've been talking about.
Absolutely. Chapter 20 gets to the core of acting with integrity in this field. Administrative officials have a lot of power, and their decisions can have a huge impact on people's lives. This chapter says that ethical conduct isn't just a personal choice. It's crucial for keeping public trust, upholding the rule of law, and making sure power is used for good.
So we're talking about honesty, fairness, impartiality, respect for the law, those core values.
Exactly. Chapter 20 might explore the ethical principles that should guide administrative decisions. Things like acting in good faith, avoiding conflicts of interest, using public resources responsibly, and treating everyone with dignity and respect. It might even look at codes of conduct for officials and the systems for dealing with ethical violations.
It's like we're building a culture of integrity within the system itself. It's not enough to just have laws. People need to be committed to those values in everything they do.
You're right. Chapter 20 might even talk about ethics training for officials, encouraging them to think about their values, improve their ethical reasoning skills, and make decisions that are not just legal, but also morally right.
I see how this connects back to those earlier chapters about fairness and reasonableness. Ethical conduct is a part of all of these principles.
Exactly. Chapter 20 also recognizes that ethical challenges can come up in specific areas of administrative law, like immigration, environmental protection, or social welfare. Officials often have to make tough decisions when resources are limited or the law isn't clear.
It reminds me of Lucy, the terminally ill prisoner who was denied parole. I imagine there were some complicated ethical questions in that case.
You're right, and Chapter 20 might use that exact scenario to explore the ethical principles that guide parole decisions, balancing public safety with a prisoner's right to dignity, rehabilitation, and compassionate release when they're terminally ill. Those are tough calls.
And it's not just about individual cases, it's about how ethical principles guide the whole system.
You got it. Chapter 20 encourages us to think about the values behind administrative action and to understand that ethical conduct is essential for a truly just system.
This deep dive has been amazing. We've traveled not just through legal concepts, but also through the values that shape how those concepts are applied. What's next? Chapter 21 sounds really interesting. The role of public participation in administrative law. It sounds very democratic.
It is. This chapter focuses on citizens and communities and emphasizes how important they are in shaping administrative processes and decisions. It's about recognizing that administrative law isn't just for lawyers and officials. It's about giving the public a chance to get involved and have their say.
Okay, so like public hearings, consultations, opportunities to give feedback on new rules,
Yeah.
all that falls under this umbrella.
Exactly. Chapter 21 might look at all sorts of ways for the public to participate, both formal and informal. It'll probably talk about the benefits, like making decisions more legitimate and accountable, getting different viewpoints, and building trust between the government and the people.
Yeah, that makes a lot of sense. If people feel like they have a voice, they're more likely to trust the system.
Yeah.
But I'm sure there are challenges too, right? Like getting people to participate, making sure everyone is heard, especially in diverse communities.
Those are important challenges. Chapter 21 might look at how to reach those communities that are often left out, overcome language barriers, and create processes that are truly open to everyone. It might even dig into the legal frameworks for public participation in South Africa, looking at the Constitution, PAJA, and international standards for things like making environmental decisions.
You know, that makes me think about that scenario we talked about with the municipality planning to build a new road through a neighborhood. Public participation seems really important in a case like that.
It's absolutely crucial. Chapter 21 might analyze how public input can be used to figure out how the community will be affected, explore different options, and come up with solutions that work for everyone.
So it's about making administrative law more collaborative instead of just a bunch of rules coming from the top down.
Precisely. This chapter might even look at how technology can help with public participation. Could online platforms, social media, or other digital tools be used to improve communication, share information, and make it easier for people to get involved?
That's a great question. It sounds like technology could be really useful for making administrative law more inclusive and participatory. What are some of the potential problems or risks we should be thinking about?
Well, Chapter 21 might explore the challenges of holding consultations online, the issue of people not having access to technology, and even the possibility of manipulation or misinformation in online spaces. It's about being aware of both the good and the bad when using technology in this way.
This deep dive is really making me think about how the government and the people interact in a democracy. It's not just about one side telling the other what to do. It's about finding ways to work together, to listen to each other, and to create a system that really reflects the needs and values of the people.
That's a great way to put it. And that's the kind of thinking Chapter 21 encourages. It's about using administrative law to build a society that's more participatory and inclusive, where everyone feels empowered to shape the decisions that affect them.
Okay, we have 2 chapters left. What's next?
Chapter 22 takes us into the future. It's called The Future of Administrative Justice, and it explores the big trends, potential problems, and creative solutions that might shape this area of law in South Africa and around the world. It's a chance to think big and see where things might be going.
This sounds exciting. What kind of trends and challenges are we talking about?
Well, think about the major issues facing the world today: climate change, rapid technological advancements, social inequality. Chapter 22 might look at how administrative law can help us address these challenges. How do we balance economic growth with protecting the environment? How do we create rules for new technologies like AI? How do we ensure that administrative systems are fair and accessible to everyone regardless of their background?
Wow, those are huge questions. It sounds like administrative law has a really important role to play in making a better future.
Exactly. This chapter encourages us to think creatively and imagine how administrative law can be a force for good change, not just a set of rules and regulations.
So we're looking beyond the current system and imagining a future where administrative law helps promote social justice, protect the environment, and empower communities.
Exactly. And it's not just about South Africa. Chapter 22 might also look at how international cooperation in administrative law is becoming more and more important. Can different countries work together to solve problems that cross borders, streamline procedures, and share the best ways to ensure good governance and protect human rights?
So we're shifting from national concerns to a global perspective, understanding that these issues affect everyone.
You got it. Chapter 22 encourages us to think broadly and creatively about the future of administrative justice. It reminds us that this is a shared responsibility involving citizens, communities, governments, and international organizations working together.
Okay, on to our second to last chapter, Chapter 23. What does it cover?
Chapter 23 dives into accountability and transparency in administrative law. It's a fitting way to wrap up our journey because it highlights two of the most important principles for good governance.
Accountability and transparency. Those are essential for making people trust this system. What are some of the key things about these concepts?
Chapter 23 might explore South Africa's Promotion of Access to Information Act, which gives you the right to request government records. We could also discuss whistleblower protection laws, which encourage people to report wrongdoing without being afraid of getting in trouble.
Those sound like important ways to protect against corruption and abuse of power. It's about being open and making it harder for bad things to happen secretly.
Exactly. And Chapter 23 might look at how technology can help make things more transparent and accountable. Could online platforms be used to share government data, track spending, and keep citizens updated about decisions being made?
That's a great idea. It's like using technology to make government actions more visible. And this makes me think back to what we talked about with the right to reasons. Giving clear and understandable reasons for decisions is a big part of transparency, right?
Absolutely. Chapter 23 emphasizes that giving reasons is a form of accountability. It makes those in power explain how they thought through their decision and justify their actions.
So it's not just about making a decision, it's about explaining why you made that decision in a way that people can understand and maybe even question.
Precisely. It's about having a system where decisions aren't random or based on personal opinions, but are grounded in reasons that everyone can see. This chapter shows that accountability and transparency are super important for a democracy to be healthy. When people trust their government and feel like they can participate, everyone wins.
This has been such a fascinating deep dive. We've explored so much from the basic ideas to the complex challenges, and even got a glimpse into the future of this area of law.
It's been a great journey, and I hope our listeners feel like they can keep exploring this area of law.
I'm sure they do. Okay, so before we wrap up, is there one main thing you hope our listeners will remember from all of this?
I hope they remember that administrative law isn't just about bureaucracy and paperwork. It's about making sure that power is used responsibly, that people have a voice, and that everyone has a fair chance to get justice. It's about creating a society where the government serves the people and where the law matters.
That's a perfect way to put it. Thanks for joining us on this deep dive into the world of administrative law in South Africa. It's been a pleasure exploring these ideas with you, and I'm sure our listeners feel the same way.
I've enjoyed it too. To our listeners, keep learning, stay curious, and never forget that you have the power to make a difference.
And that brings us to the end of our deep dive into administrative law in South Africa. We hope you found this exploration informative and engaging.
Until next time, keep those legal gears turning.
From all of us here at the Deep Dive, thanks for listening.
It's about recognizing that administrative law isn't just for experts and officials. It's about creating opportunities for the public to really engage and have their voices heard.
So things like public hearings, right?
Yeah.
And consultations, chances to give input on proposed regulations. Those all fall under public participation.
You got it. Chapter 21 might explore a bunch of different mechanisms for public participation. Some are formal, some are informal. We'll probably talk about the benefits, like how public participation can make decisions more legitimate, hold the government more accountable, and bring diverse perspectives into the mix.
Right. Bringing in those different viewpoints is so important, and it can help build trust between the government and the people.
Exactly. If people feel like they're actually being heard, they're more likely to trust the system. But there are definitely challenges too. It's not always easy to get people involved. And it's important to make sure everyone's voice is heard, especially in diverse communities.
Yeah, that's so true. Reaching those marginalized communities, overcoming language barriers, creating processes that are truly accessible and inclusive, those are all important things to consider.
Absolutely. Chapter 21 might even look at the specific legal frameworks for public participation in South Africa. We might examine the Constitution, PAJA, and even international standards for things like environmental decision-making.
You know, that reminds me of that scenario we talked about earlier with the municipality planning a new road through a residential area. Public participation seems absolutely crucial in a case like that.
It is. Chapter 21 might analyze how getting the public involved can help identify the impacts on the community, explore different options, and maybe even negotiate solutions that work for everyone.
So it's not just about following the rules. It's about using administrative law to make decisions in a collaborative way.
Exactly. And this chapter might even look at how technology can play a role in facilitating public participation. Things like online platforms, social media, digital tools. Can these things enhance communication, make it easier for people to share information and get involved?
That's a great question. I can see how technology has the potential to make administrative law much more participatory and inclusive, but I imagine there's some potential downsides too.
Of course. Chapter 21 will probably explore the challenges of online consultations, the potential for some people to be excluded if they don't have access to technology, and even the risks of manipulation or misinformation spreading in those online spaces.
Right. It's not a perfect solution,
Yeah.
but it's definitely something to think about. This deep dive has really been eye-opening. It's made me think about how the government and the people interact in the democracy. It's not just about one side dictating to the other. It's about finding ways to work together, to listen to each other, to create a system that really reflects the needs and values of the people.
I couldn't have said it better myself, and that's the kind of thinking that Chapter 21 encourages. It's about using administrative law as a tool to build a society that's more inclusive and participatory, one where everyone feels empowered to shape the decisions that affect their lives.
Okay, so we've only got 2 chapters left. What's up next?
Chapter 22 takes us into the future. It's called The Future of Administrative Justice, and it's all about exploring those big trends and potential problems that might shape this field in South Africa and beyond. It's a chance for us to think big picture.
Sounds exciting. What kind of trends and challenges are we talking about?
Well, think about the major issues facing the world today. Climate change, right? The rapid pace of technology, social inequality. Chapter 22 might examine how administrative law can step up to meet these challenges. How can we make sure economic development happens in a way that protects the environment? How do we regulate these new technologies like artificial intelligence? And how do we guarantee that administrative systems are fair and accessible to everyone, no matter who they are or where they come from?
Those are some big questions. It definitely seems like administrative law has a crucial role to play in shaping a better future.
Absolutely. This chapter encourages us to be creative, to think outside the box, and to really imagine how administrative law can be a force for positive change. It's not just about rules and procedures.
It's about using those rules and procedures to make a real difference in the world.
Exactly. And it's not just about South Africa either. Chapter 22 might explore how international cooperation in administrative law is becoming more and more important. Can countries work together to solve problems that cross borders? Can they streamline procedures and share those best practices that help ensure good governance and protect human rights?
So it's about broadening our perspective, moving beyond those national concerns to a more global view, recognizing that these issues impact all of us.
Exactly. Chapter 22 encourages us to think big, to be creative, and to remember that this is a shared responsibility. It involves everyone: citizens, communities, governments, and international organizations.
Okay, we're on to our final chapter. Chapter 23, what does it cover?
Chapter 23 takes us back to some core principles. We're talking accountability and transparency in administrative law. And it's a fitting way to end our journey because these principles are absolutely essential for good governance.
Accountability and transparency. Those are key ingredients for building trust in the system.
Right. What are some of the key elements we might see in this chapter?
Well, Chapter 23 might explore South Africa's Promotion of Access to Information Act. The one that gives citizens the right to request access to government records. We might also discuss whistleblower protection laws. Those laws encourage people to come forward and report wrongdoing without fear of retaliation.
Those are both so important. It's about making sure things are done in the open, not in the shadows. It's about making it harder for corruption and abuse of power to take hold.
Exactly. And Chapter 23 might even look at how technology can play a role in enhancing these principles. Can online platforms be used to publish government data or to track spending? Or even to keep citizens informed about how decisions are being made?
It's such a good point. It's about using technology to bring government operations out into the open for everyone to see. You got it. And this ties back to our discussion about the right to reasons. Giving clear and understandable explanations for decisions is such a crucial part of transparency. It forces decision makers to be accountable for their actions.
Right. It's not just about making a decision. It's about being able to explain why you made that decision in a way that people can understand and maybe even question.
Exactly. It's about creating a system where decisions are grounded in logic and reason, not in whims or personal opinions. And that's what builds trust. Accountability and transparency are the cornerstones of a strong democracy.
It's been such a fascinating journey exploring the world of administrative law with you. I feel like I have a much deeper understanding of how the system works now and the values that underpin it.
Me too. It's been a pleasure diving deep to these concepts with you.
Well, to our listeners out there, thank you for joining us on this deep dive into the fascinating world of administrative law in South Africa. It's been a real pleasure having you along for the ride.
Until next time, keep those legal gears turning.
And from all of us here at The Deep Dive,